Let's begin with the Bauserman versus Unemployment Insurance Agency. Please proceed.
Good afternoon. May it please the Court. My name is Jennifer Lord, and I'm appearing on behalf of the appellants. My co-counsel are Kevin Carlson and Michael Pitt. Appellants would like to reserve 3 minutes for rebuttal and also waive the no question zone. This case affords a narrow and straightforward way for the Court of Appeals to answer its question about accrual. Appellant's approach is consistent with this Court's determinations in Frank, in Millar, and most importantly, it's consistent with Article 1, Section 17 of the Michigan Constitution. And that's the starting point. What is required to bring a claim under Article 1, Section 17? What's the cause of action? Two things have to occur. There has to be a deprivation of property, and that deprivation of property has to have been done without due process. So looking at a constitutional tort in a little bit different manner, there are two elements to this particular constitutional tort, and the tort is not complete until both elements are met. And the clear and straightforward way that this Court can give guidance to lower courts and to litigants who appear to be struggling with this accrual issue is to start by focusing on the cause of action. And I think that that's what this Court did in both Frank and Millar. In Frank, the Court asked many questions during oral argument and referred many times in its opinion to what's the focus of this cause of action? What does the minority shareholder oppression statute protect? And what that statute protects is that a member's interests are not going to be interfered with in a substantial way. That's when the harm accrued. The statute defined it. That's when the harm accrued. In that case, the harm diverged from the damages. And the Court also in Frank pointed out that tort cases might be different. And tort cases are different. They're not all different in the same way. But in Bauserman, the harm coincided with the damages. And it also did in Millar. And I'd like to take a few minutes and explain why Millar also provides important guidance on this accrual issue. In Millar, it was an employment case, and I'm an employment attorney, so I like to think of things in terms of elements and adverse action. The employee was terminated as a result of a letter that his employer had received basically from an outside contractor. And the letter predated the actual termination of the services. And the Court was asked to determine whether or not the letter, which would have been outside of the statute of limitations for the Whistleblower Protection Act, was the event giving rise to the cause of action, or whether or not it was the actual termination. And the Court ruled that it was the effectuation of the decision, the implementation of that prior decision that was the key point for accrual in statute of limitations purposes. Similarly, in this case, the effectuation of these letters that went out in the mail, these determinations that said, hey, we think you committed fraud. Here are some appeal rights, but you have to do X, Y, and Z to exercise those appeal rights. That was just notifying the plaintiffs of something that might happen. That was not a final order. It was only when the defendants, the appellees, implemented that quote-unquote decision, to the extent that it really was a decision, did the case accrue for a constitutional deprivation of property without due process.
Counsel, may I take advantage of your waiver of your free fire time and ask you what I think is a threshold question in this case? Can you explain to me, I understand both parties agree on this, but nonetheless, I'm not quite aboard yet, and I wonder if you could explain to me how the plaintiff's cause of action in this case is properly characterized as one for property damage or personal injuries.
Sure. It's because that's how we defined it in our complaint. It is a constitutional tort is inherently one for property damage. Well, this constitutional tort, is inherently one for property damages. And we talked about that at paragraph 151 of our complaint. And I'll read it, it's brief. The central question of law, common to all class members, is whether defendants' interception and seizure of state and federal income tax refunds, garnishment of wages, and/or demands for repayments, assessment of penalties, imposition of interest on penalties, and unauthorized collection methods are made without due process, including the fair and just treatment as required by Article 1, Section 17 of the Michigan Constitution.
So you think the recovery of that kind of property is fairly characterized, I assume not as personal injury, as a personal injury cause of action, but as a property damage cause of action?
Correct. What the Court of Appeals erred and what the appellees misapprehend is the true nature of the plaintiff's cause of action. And the
Counsel, what's the deprivation in this case? You referred to the letter.
Sure.
A few moments ago.
What's
the deprivation that you're claiming on behalf of each of the individual plaintiffs you represent?
The deprivation was the seizure of the tax refunds and/or administrative garnishments, which are automatically applied. They're non-appealable. They're 25% administrative garnishment. And so, why this case is
isn't the termination of benefits itself a deprivation of property?
This case does not involve a termination of benefits. It can be for some of the members of the putative class action. It may be true that when they were falsely accused of having committed fraud, if they were still collecting benefits, those benefits would terminate. And then if they later became eligible for benefits, those benefits would be reduced.
I thought those facts were present in Mr. Williams' claim, at least, that he was receiving unemployment benefits which were terminated.
He was receiving unemployment benefits that were terminated. And excuse me one second. What he did is he found new work. He reported to Marvin, which is the internal reporting system, that he had found new work. And for some reason, his benefits were not properly reduced. They should have been reduced. And so when that didn't happen, as a matter of error, he was overpaid for a period of time. So his deprivation, though, and all of the claimants' deprivation is linked to the first time that the agency took action to seize their property. Mr. Bauserman is a perfect example, and I'd like to give a brief timeline of what happened to him to show why this case is timely under the Court of Claims Act, specifically subsection 3. He received his notice of his determination of fraud in early December of 2014. The very next day, he appealed. He did everything that the agency told him to do. And then the agency waited a little over 6 months, and in June of 2015, they seized his tax refunds. And that is the date when he was damaged and when this cause of action arose. Now, many people weren't as fortunate as Mr. Bauserman, and I think that this is an important factual distinction for the court to understand. Mr. Bauserman was lucky. He decided to go on his portal, this online portal, after he had stopped collecting benefits. Most people would never think to do that because there's no reason to. So for the vast majority of the plaintiffs in this case, their very first notification that the agency might have considered they did something wrong was when their tax refunds were seized. And to hold that an initial determination is the accrual date is fundamentally unfair. And I do think that it makes some sense to look at this through the lens of the harsh and unreasonable consequences doctrine.
Counsel, let me just clarify on the point. So are you not claiming on behalf of your clients any deprivation based on the termination of benefits? Is that not part of this case, or is it?
There are several different deprivations, and they're different for each of the claimants. What happened for the most part is that people had their deprivations when they experienced administrative garnishments or seizures of their tax refunds. For a smaller subset,
You're saying some people already had their benefits terminated? Is that what you're saying?
the natural course of how this happened was that the people who were impacted, and I can't think of anyone where this doesn't apply with the exception of possibly Mr. Williams, they had long ceased collecting unemployment benefits when the deprivations occurred. And so where they experienced later later damages was in a situation where that individual went and got a new job, was laid off from the new job, went to reapply for the benefits, and then those benefits were either completely eliminated or they were reduced. So back to what I think the fundamental error of the Court of Appeals was, and it's stated very clearly in the introduction of the opinion. In this case, individuals who have filed a class action alleging that defendant violated their rights to due process when investigating whether plaintiffs committed fraud in receiving unemployment benefits. This is not a class action alleging that defendant violated their rights to due process when investigating them. There's no violation of due process. The Constitution doesn't prohibit a deprivation of due process for due process's sake alone. And that is what the Court of Appeals found, and that is what the appellee is arguing. There are these fundamental rights that every Michigander under the Constitution is entitled to, and a hallmark is not to be deprived of their property without due process. I see my time has run. Thank you.
Good afternoon, Aaron Lindstrom on behalf of the Unemployment Agency. I'm joined at council table by Assistant Attorneys General Debbie Taylor and Jason Hawkins. Mr. Chief Justice, may it please the court. The question in this case is what triggers the 6-month time period. And there's two possible theories, but the Unemployment Agency prevails under either. The one is you focus on the event. That's what MCL 600.6431 says, the event that gives rise to a claim. That's our theory. Their theory is that you focus on when it's finally accrued, but in either event, the agency still would prevail. As to what the event was that gives rise to their claim, it's when they received these determinations through the method that they specifically elected to receive notifications from the agency by, which is electronic notification. They received a determination. This is Mr. Bauserman's. It's page 24B of our appendix, if you want to look at it. And it says you are ineligible, and it lists the money that he received in payment that shows he was not eligible. He also received notice that he committed misrepresentation, and this says he's disqualified, restitution is due, you're required to pay the penalty. And then it also included a list that shows what that restitution was going to be separately from what the penalty was going to be.
Is it your position?
So I'll waive if you.
I apologize. I apologize. But is it your position that that amounts to, that letter, that notification, to a deprivation of property?
I think it's, first of all, in the plain language, it's the event that gives rise to the claim. And then if you're going to go with the later deprivation of property, that's kind of the third way we'd prevail. The actual deprivation of property occurs 30 days after each one of these when it becomes final. And as it says on these, if you don't appeal within 30 days, it becomes final. And for example, for Mr. Bauserman, he appealed one of the two determinations, not both, so I want to correct that because I think our brief may have not been clear on that. He did appeal the fraud determination, so that would mean he's challenging the penalties, but he did not appeal the determination that he was ineligible, and that means he still has restitution, as it says here,
Mr.
was not
Lynch,
appealed,
going
was
back,
final.
forgetting about the specific facts, just going back to Justice Viviano's question about the event that gives rise to the claim, is it your position that anytime the state bills me, for something I don't actually owe, I have a claim, I can sue the state? I'm worried this is short-sighted as a taxpayer. I'm a little worried about, like now, for example, I had my identity stolen 5 years ago, and every year I get a letter from the IRS and one from the state treasury demanding tax refund, tax payments that I don't owe, and I have to go through the process of reminding them about when the Chinese stole my identity, and it always works out in the end because thanks to the process that I get. But are you saying that I now can actually file a lawsuit every time I get that letter, because that's the event that gives rise to the claim?
I think if you are alleging you're deprived of due process, even if you haven't suffered any injury yet, that's what Carey versus Pifus says. It says even if the ultimate determination would come out in your favor.
It's not going to be a lot of people who are going to be able to file lawsuits against the state. I mean,
it may mean that. So the only reason I'm making this argument is that's what the U.S. Supreme Court has said. The U.S. Supreme Court has said it is actionable. That's their language. They say a procedural due process claim has accrued. So if we're under the accrual framework.
But I thought a due process claim only is actionable once you've deprived me of either liberty or property. And when I get the letter, I think I'm mad. It's a big pain in my. It's not fun.
Right.
To have to go through these steps every year, and I'm annoyed. But I didn't know I had a right to sue based on a due process violation. I thought I had to go get some process so I could.
That's what Carey versus. It says the injury is mental and emotional stress that you've suffered. Even if there's no actual injury later, then you only might be. It changes the amount of damages you might get, so it might never be worth it to you to sue. But if there's no actual effect of that lack of process, then why would you want to sue? But you'd still be entitled to sue for nominal damages. So even under their accrual framework, that means that it's still the same event.
But I get that reading of Carey because the students had already been suspended in Carey. So I think I feel like you're talking past me on Carey. And in Carey, you're right. It went as to damages. It turns out there were none. But when the claim was brought, that the deprivation had happened, the students had been suspended.
So, first of all, I've got an argument that the deprivation happened here, but under Carey versus Pifus, it specifically, the deprivation, they didn't try to calculate the amount of money, there's what they say for remand, for whether or not the days in class that they missed, 8 days for one student, 20 days for other students, that those, to try to figure out what that was. But they said even if it's just nominal damages, they still could bring their claim, so they could go back and figure out if they're entitled.
Because they had been deprived of a liberty interest. That's why they get to bring.
And the liberty interest was the actionable component of it was the lack of notice and opportunity to be heard, and that was they're entitled to that constitutional right.
Absolutely, well, right, but only because there was a deprivation. I'm not entitled to due process not to be billed inappropriately. I don't think. Maybe I now am in Michigan, and wow. Because it's going to happen.
Well, I'd be happy to talk about the two other theories we have that I think answer the question equally. If I'm not persuading you.
But I don't mean
one.
to hog the time. So
that's fine. So,
but I have a question though, because
so, Counsel, you think we should be looking at the started into motion standard in determining when the accrual process begins?
I do. I think that is the language that is in 6431.3, and it's very different from the words that appear in 6431, the first paragraph. There, it talks about accrual. That says the 1 month or the 1 year time period begins when the claim accrued. Whereas in subparagraph 3, it says the happening of the event that gives rise. And it seems odd to me that the legislature would go through all of the trouble of using this long, convoluted phrase when they could have just said accrued. And the ordinary rule is that if they use different language, it has different meaning.
Yeah, I agree with you completely that you're engaged in the proper analysis by recognizing that the language is different in these provisions, and we have to assume that they communicate something different. But in terms specifically of the start into motion standard, I guess my question, and I think this is a bit of a stretch, but why didn't the actual receipt of the unemployment benefits start things into motion? How far back do you go? How do I know when the start into motion process does or doesn't begin? It just seems to me like it's a fairly vague and hard to ascertain standard.
Well, it's a pleading standard in 6431, and what you're supposed to plead is the happening of the event. And here it seems very concrete. Their claim is that they had an automated system that adjudicated their guilt without notice or an opportunity to be heard, and all of that was known by the time they received these. They know I've got this adjudication, and they know the amount of money down to the penny I have to itemize to say what my damages were, and they know that I didn't get the notice and the opportunity I was supposed to get.
But just tell me specifically how the redetermination communicates something different than, say, the receipt of the unemployment benefits. The former moment in time is distinct from the latter moment in time. Why exactly?
Because when they were receiving the benefits, they weren't harmed by the government. Their allegation is we were harmed by the government when the government took away these benefits, right? So the event that gives rise to their cause of action that would say that they were harmed was this thing that the government did that they didn't like. So receiving benefits can't be it because they like getting the benefits.
So what's wrong with me saying that in order to have established the harm that we're focusing on here, there has to be not merely a due process deprivation, but specifically a deprivation of property? What's wrong with me saying that? What am I missing in suggesting that there has to be the actual deprivation of property at some point, because the two in tandem are what define the constitutional violation?
I think that the part is the language is the happening of the event giving rise. So that language is something less, I think, than the full accrual of a claim. A claim is fully accrued, which talks about when it has accrued in the first subparagraph. But in the third paragraph, it says the happening of the event that gives rise to the claim. And as we cited in our brief, I think it was page 11 and 12, we quote from the Dictionary of Modern Legal Usage. It gives examples of where these things mean different, where these phrases mean different things. So, for example, exposure to asbestos might mean your claim starts to arise, but it doesn't actually accrue until you contract asbestosis. So that's an example of how these words are different.
So you think accrual actually precedes the point at which a claim of action becomes essentially realizable?
I think the event giving rise to the claim precedes the claim, absolutely. I think that's what the plain language means. And it makes sense in this context, too, where we're talking about injuries that the state might be able to go out and fix.
But, Counsel, I have a question, though, and I know you've been getting hit with a lot of questions, but you said that makes sense, and I just have to ask the question, does that really make sense? Do you really think that this is, do you really think this is an appropriate bar that you're putting on the citizenry? So basically, what you're ultimately saying, I'm a big fan of trying to keep things simple. I think sometimes the law is best when it's done in a more simplistic fashion. So basically, your entire argument is that an innocent citizen who basically is struggling just to try to get through the day and make their payments, that they should have done two things. I just want to make sure I get the essence of your argument. That when they got this letter and they got this restatement, that number one, they should have done two things. Number one, they're looking at it and they realize they know it's a mistake, they know it's incorrect, they know it's not accurate. So they needed to, number one, go and handle this issue, making sure that they correct the issues that were misstatements. But then your second component to your argument is that at that moment, at that time, at that instant, they needed to file a lawsuit. Because because that's when their clock strikes and that's when their clock ticks in terms of basically having a chance to have recourse. And I guess when you make the argument that you feel that this actually makes sense, my question to you, is that really sensible that you're asking the citizenry to ultimately do that? Because wouldn't it be fair to say, when you get a restatement like this, wouldn't it be fairer for a citizen to look at it and say, wow, this was a mistake, I better try to figure this out and try to get this handled and figure out what took place and just get myself back in order so I don't lose my house and my car and, basic essence before I figure out what my recourse is going to be? Isn't that a more sensible, or when you say that makes sense, doesn't that make more sense? That basically it's almost as bad as having to go to the Secretary of State's office. Dealing with this department would be worse than having to go to the Secretary of State. So my question is, you want them to have to go and deal with all this, And then what you're saying to them on top of that is, oh, by the way, the clock has started, and if you don't do this right away, you don't have a cause of action. It's a long question, but I really would like we're going to take some time. So take as much time as you want to answer the questions, because I think this court has a lot of questions for you, but I want you to explain and answer in detail that question.
Mr. Chief Justice, may I answer?
Please.
So first of all, this is not a bar that I made up or my office or even the unemployment agency made up. This is something the legislature adopted, and it doesn't require filing a complaint, as you suggested. It requires following just a notice that has these minimal piece of information. And I think there is a good reason for this rule, and it's to give the state a chance to fix a problem if it's injuring somebody. It's kind of like the highway exception. We require people, if there's a bad problem with the road, to provide us notice about where the injury is. And part of the reason for that is so that we can do something about it, right? So this is kind of an information forcing rule that encourages people not to sit on their injury for 2 or 3 years, whatever the appropriate statute of limitations is, while they write the perfect complaint, but rather to send this minimal notice out at the outset so that perhaps the state can fix something if it's doing something wrong,
and you think
so
the
this
general,
unfortunate thing doesn't happen to someone else.
Wait, you think the general citizen knows that this is what they have to do right away? Do you think that, was it your position that, people would be aware of this and would know that this is what they have to do?
Well, this court and the U.S. Supreme Court have both recognized, I think it's Texaco, that it's a fundamental premise of our democratic system that the people are able to know and understand the law. So this is a statute that's out there. That means there's notice of it. People are supposed to. We don't require everybody to have actual notice of every law. We couldn't have a system like that. This is readily understandable.
So you don't think that that the way that the legislature intended this is when a citizen gets this notice and they think it's a mistake, you don't think that the general conception of this would be for that individual citizen to try to get to the bottom of it and actually try to get the payments restored before they would try to have to seek recourse? I mean, you really think that that is the appropriate interpretation, rather than most people, when they get a notice like this, they basically look at this as either it's a negotiation or a discussion or something. They don't look at this as like an end result. Wouldn't it be fair to say that they're two separate events and that ultimately you don't recognize that this is an end result until you actually have the garnishment? Because the garnishment is real. This could be a computer mistake. This could be a misinterpretation. This could be the beginning of a negotiation. In many situations, when government sends you materials of this sort, the expectation is that they want you to negotiate. They want you to come in and have a conversation. They want you to have a discussion. So wouldn't it be fair that people look at this not as an ending determination, but rather as the salvo, the beginning for a discussion over their issue? But the ending component, where it's final, comes when they actually feel the weight of the garnishment.
So, Your Honor, the record shows in the Exhibit 21 to the motion to dismiss that on January 13th, Bauserman, for example, received a letter that says, you received a determination that you were overpaid. This has not been appealed and is now final. This debt is legally enforceable. So I think this is an instance where a person getting this would realize this is serious, and I now have a legal debt, which actually the existence of the legal debt goes to my third theory of why this is approved.
See that I get this. They would see that this is serious. I don't think there's any question that if you get a notification like this, that you think it's serious. But in many situations in dealing with the government, it's not seen as the final component. It is seen as either a warning or a notice or something other than the finality. It's the finality. It's the sense that you've actually lost your actual money, that your money is taken away from you. That's when this becomes real to most people. And don't you think it's just more sensible in terms of when we're talking about a statute, that it becomes more reasonable when it actually happens?
Again, it has happened. This notice says it is now final. It is legally enforceable. That's what they received.
Can we hear your third argument on why the legal debt being asserted by the state is sufficient to accrual?
That is the argument, that for each of these individuals, 30 days after the appeals process ended, each one of them had not appealed all of the legal debts that were imposed on them. And since those legal debts took effect, they had suffered a deprivation of property. So even under the theory that you need a deprivation of property, here there was a deprivation of property when you include this legal debt. That is something, it's just like if a court enters a judgment, that's a legal debt, even if the collection doesn't follow for a while afterwards, it still changes your bottom line. It's
How
still
is
something-
a legal debt different than the state just sending you a bill?
This is a debt that's been determined by the administrative hearing process. It's something that is binding. I think a tax, I don't know. I mean, this may be different than taxes. I didn't study the tax side of it, but this specifically says on it, this debt is legally enforceable. So to the extent there are other ones that are not clear, this one's clear. If there are any other questions, I'd be happy to answer them. Otherwise, I'll yield. Thank you, Mr.
Thank you
Chief
very
Justice.
much.
Under the appellee's theory, the plaintiffs would have had to file their lawsuit while they were still pursuing their appeal rights with the agency. Mr. Bauserman did not sit on his rights. He timely appealed, and in fact, the agency didn't rule on his appeal until after we filed this lawsuit, at which point they voided that determination. That determination is a legal nullity. A legal nullity cannot be the point at which a cause of action can accrue. This case is exactly like, the notice of redeterminant in this case is exactly like the earlier letter in Millar. It expresses the agency's intent to deprive, but it doesn't effectuate the decision. Exactly the same in Millar. People got a letter in the mail expressing an intent, giving them their appeal rights. The plaintiffs did appeal. And it's important to note that the agency has overturned 40,000 of these determinations. That doesn't erase the damages that these people experienced. And I want to just briefly address Carey v. Pifus. All Carey v. Pifus said was that when you have only a procedural due process violation, not a substantive one, a procedural one, in that case, you're entitled to nominal damages. And the Supreme Court in Carey remanded that case to the district court to make a determination. And if those students shouldn't have been suspended, if they experienced more than a procedural due process violation, they would be entitled to further damages. Thank you.
Thank you very much, counsel. Thank you, Mr. Lindstrom.